5 seconds. Start. The provisions of Civil Procedure Code are intended to provide expeditious grant of decree in favor of a plaintiff in a suit or proceedings where the defendant has made any admission in the pleadings or otherwise orally or in writing of any amount due full stop. The plaintiff would be entitled to a decree on the basis of such admission without waiting for completion of the trial full stop. The provisions were incorporated by way of amendment full stop. The legislative object of these provisions is to restrict the period for determination of disputes between the parties to a suit and ensure that a decree on admission is passed without any unnecessary obstruction full stop. The expression admission has been given a wider meaning so as to take with its ambit admissions made by a party in pleadings or otherwise orally or in writing full stop. These provisions thus are capable of liberal construction and without imposition of any unreasonable restriction must be permitted to operate, but the courts have to be careful while passing a decree on admission full stop. The court essentially should look into the fact that all essential ingredients of an admission are satisfied before such a decree is passed in favor of any of the parties to the suit full stop. Admission has to be unambiguous, clear, and unconditional, and the law would not permit admission by inference as it is a matter of fact full stop. Admission of a fact has to be clear from the record itself and cannot be left to the interpretive determination by the court unless there was a complete trial, and such finding could be on the basis of cogent and appropriate evidence on record full stop. Learned counsel for the appellant contended the rule comes under the heading admissions, and a judgment on admission could be given only after the opportunity to the other side to explain the admission, if any made, that such admission should have been made only in the course of the pleadings, or else the other side will not have an opportunity to explain such admission, that even though the provision reads that the court may at any stage of the suit make such order as it thinks fit, the effect of admission, if any, can be considered only at the time of trial, that the court need not necessarily proceed to pass an order or a judgment on the basis of such admission, but call upon the party relying upon such